At the Umansky Law Firm, we believe everyone deserves a second chance.
Up until this point, we've talked about when victims are uncooperative with prosecution and they don't want to go forward with prosecution. But what if they do? What if the victim in the case definitely wants to go forward with prosecution against the defendant? And in this case, maybe the victim is very much in fear. What will happen is the state attorney's office will reach out to the victim and basically get their position. If this is a situation where the victim just wants the person to get some type of treatment, maybe mental health counseling or substance abuse treatment, a lot of times at that initial contact, the state attorney's office will ask the victim about that information. But if it's a situation that the victim was hurt relatively badly, or if the victim believes that jail time is appropriate, this is also the appropriate opportunity for the victim to discuss that with the state attorney's office. Normally, this type of discussion will lead to the state attorney's office filing charges against the defendant. Now, if the defendant is charged with only a misdemeanor charge, the defendant usually, when they bonded out of jail, will have an arraignment court date. That arraignment court date is where you will find out what you're specifically being charged with. If you hire our law firm or any other private law firm, normally you will know what you're being charged with before that arraignment date. Also, we will waive your appearance at that arraignment date by filing special pleadings telling the judge that we are representing you, we waive your appearance at the arraignment, and that we will take responsibility for telling you what you're being charged with. Now, if it is a felony court case and a felony is filed on, the judge, as soon as the case goes to the clerk's office, will assign you an arraignment date.